Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Lamps Plus Incorporated versus Varela. Certiorari to the United States Court of Appeals for the Ninth Circuit. Argued October 29, 2018. Decided April 24, 2019. In 2016, a hacker tricked an employee of petitioner Lamps Plus Incorporated into disclosing tax information of about 1,300 company employees. After a fraudulent federal income tax return was filed in the name of respondent Frank Varela, a Lamps Plus employee, Varela filed a punitive class action against Lamps Plus in federal district court on behalf of employees whose information had been compromised. Relying on the arbitration agreement in Varela's employment contract, Lamps Plus sought to compel arbitration on an individual rather than a class-wide basis and to dismiss the suit. The district court rejected the individual arbitration request, but authorized class arbitration and dismissed Varela's claims. Lamps Plus appealed, arguing that the district court erred by compelling class arbitration, but the Ninth Circuit affirmed. This court had held in Stolt-Nielsen v. Animal Feeds International Corporation that a court may not compel class-wide arbitration when an agreement is silent on the availability of such arbitration. The Ninth Circuit ruled that Stolt-Nielsen was not controlling because the agreement in this case was ambiguous rather than silent on the issue of class arbitration. And I'm slightly changing the way I read this. Supreme Court held, reversed, and remanded. Chief Justice Roberts authored a 5-4 opinion. This court has jurisdiction in order that both compels arbitration and dismisses the underlying claims, qualifies as a final decision with respect to an arbitration within the meaning of 9 U.S.C. Section 16A3. The jurisdictional provision on which Lamps Plus relies. See Green Tree Financial Corporation versus Randolph. Varela attempts to distinguish Randolph on the ground that the appeal here was taken by the party who had already secured the relief it requested, i.e. Lamps Plus had already obtained an order dismissing the claim and compelling arbitration. But Lamps Plus did not secure the relief it requested since it sought individual rather than class arbitration. The shift from individual to class arbitration is a fundamental change, see Stolt-Nielsen, that sacrifices the principal advantage of arbitration and greatly increases the risks to defendants. See AT&T Mobility versus Concepcion. Avoiding these consequences gives Lamps Plus the necessary personal stake to appeal. Camreta versus Green. Under the Federal Arbitration Act, an ambiguous agreement cannot provide the necessary contractual basis for concluding that the parties agreed to submit to class arbitration. Arbitration is strictly a matter of consent. Granite Rock versus Teamsters. And the task for courts and arbitrators is to give effect to the intent of the parties, Stolt-Nielsen. In carrying out that responsibility, it is important to recognize the fundamental difference between class arbitration and the individualized form of arbitration envisioned by the FAA. Class arbitration sacrifices the principal advantage of arbitration, its informality, and makes the process slower, more costly, and more likely to generate a procedural morass than final judgment. Concepcion. Because of such crucial differences, Stolt-Nielsen, this court has held that courts may not infer consent to participate in class arbitration absent an affirmative contractual basis for concluding that the party agreed to do so. Silence is not enough. That reasoning controls here. Like silence, ambiguity does not provide a sufficient basis to conclude that the parties to an arbitration agreement agreed to sacrifice the principal advantage of arbitration. Concepcion. This conclusion aligns with the court's refusal to infer consent when it comes to other fundamental arbitration questions. See First Options of Chicago Incorporated versus Kaplan. The Ninth Circuit's contrary conclusion was based on the state law contra proferentem doctrine, which counsels that contractual ambiguities should be construed against the drafter. That default rule is based on public policy considerations and seeks ends other than the intent of the parties. Such an approach is flatly inconsistent with the foundational FAA principles that arbitration is a matter of consent. Stolt-Nielsen. Varela claims that the rule is non-discriminatory and gives equal treatment to arbitration agreements and other contracts alike. But an equal treatment principle cannot save from preemption general rules that target arbitration either by name or by more subtle methods, such as interfering with fundamental attributes of arbitration. See Epic Systems Corporation versus Lewis. This conclusion is consistent with the court's precedents, holding that the FAA provides the default rule for resolving certain ambiguities in arbitration agreements. That'd be Mitsubishi Motors Corporation versus Solar Chrysler Plymouth Incorporated. Again, the decision below was reversed and remanded. Chief Justice Roberts delivered the opinion of the court, in which Justices Thomas, Alito, Gorsuch, and Kavanaugh joined. Justice Thomas filed a concurring opinion. Justice Ginsburg filed a dissenting opinion, in which Justices Breyer and Sotomayor joined. Justice Breyer and Sotomayor filed dissenting opinions. Justice Kagan filed a dissenting opinion in which Justices Ginsburg and Breyer joined, and in which Justice Sotomayor joined as to Part 2. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at Rhodes Scholar 80, that's ROADS and 80, and feel free to give any advice you have on reading these or just contact us to talk. Thanks.